Florida v. Riley, U.S. Supreme Court, 1989. Justice White announced the judgment of the court and delivered an opinion in which the Chief Justice, Justice Scalia, and Justice Kennedy join. On certification to it by a lower state court, the Florida Supreme Court addressed the following question: whether surveillance of the interior of a partially covered greenhouse in a residential backyard from the vantage point of a helicopter located 400 feet above the greenhouse constitutes a search for which a warrant is required under the Fourth Amendment and Article 1, Section 12 of the Florida Constitution. The court answered the question in the affirmative. Respondent Riley lived in a mobile home located on 5 acres of rural property. A greenhouse was located 10 to 20 feet behind the mobile home. 2 sides of the greenhouse were enclosed, the other 2 sides were not enclosed, but the contents of the greenhouse were obscured from view from surrounding property by trees, shrubs, and the mobile home. The greenhouse was covered by corrugated roofing panels, some translucent and some opaque. At the time relevant to this case, 2 of the panels, amounting to approximately 10% of the roofing area, were missing. A wire fence surrounding the mobile home and the greenhouse and the property was posted with a "Do Not Enter" sign. This case originated with an anonymous tip to the Pasco County Sheriff's Office that marijuana was being grown on respondent's property. When an investigating officer discovered that he could not see the contents of the greenhouse from the road, he circled twice over respondent's property in a helicopter at the height of 400 feet. With his naked eye, he was able to see through the openings in the roof and 1 or more of the open sides of the greenhouse, and to identify what he thought was marijuana growing in the structure. A warrant was obtained based on these observations, and the ensuing search revealed marijuana growing in the greenhouse. Respondent was charged with possession of marijuana under the Florida law. We agree with the state's submission that our decision in California v. Serralo, which is 1986, controls this case. We arrive at the same conclusion in the present case. In this case, as in Serralo, the property surveyed was within the curtilage of respondent's home. Riley no doubt intended and expected that his greenhouse would not be open to public inspection, and the precautions he took protected against ground-level observation. Because the sides and roof of his greenhouse were left partially open, however, what was growing in the greenhouse was subject to viewing from the air. Under the holding in Serralo, Riley could not reasonably have expected the contents of his greenhouse to be immune from examination by an officer seated in a fixed-wing aircraft flying in navigable airspace at an altitude of 1,000 feet, or, as the Florida Supreme Court seemed to recognize, at an altitude of 500 feet, the lower limit of the navigable airspace for such an aircraft. Here, the inspection was made from a helicopter, but as is the case with fixed-wing planes, private and commercial flight by helicopter in the public airways is routine in this country, and there is no indication that such flights are unheard of in Pasco County, Florida. Riley could not reasonably have expected that his greenhouse was protected from public or official observation from a helicopter had it been flying within the navigable airspace for fixed-wing aircraft. Nor on the facts before us does it make a difference for Fourth Amendment purposes that the helicopter was flying at 400 feet when the officer saw what was growing in the greenhouse through the partially open roof and sides of the structure. We would have a different case if flying at that altitude had been contrary to law or regulation, but helicopters are not bound by the lower limits of navigable airspace allowed to other aircraft. Any member of the public could legally have been flying over Riley's property in a helicopter at the altitude of 400 feet and could have observed Riley's greenhouse. The police officer did no more. This is not to say that an inspection of the curtilage of a house from an aircraft will always pass muster under the Fourth Amendment simply because the plane is within the navigable airspace specified by law, but it is of obvious importance that the helicopter in this case was not violating the law, and there is nothing in the record or before us to suggest that helicopters flying at 400 feet are sufficiently rare in this country to lend substance to respondent's claim that he reasonably anticipated that his greenhouse would not be subject to observation from that altitude. Neither is there any intimation here that the helicopter interfered with respondent's normal use of the greenhouse or of other parts of the curtilage. As far as this record reveals, no intimate details connected with the use of the home or curtilage were observed, and there was no undue noise and no wind, dust, or threat of injury. In these circumstances, there was no violation of the Fourth Amendment.